The last section that we want to talk about is admissions. And then, if we get time, we'll talk a little bit about communication. When you're talking about the use of admissions, what are the benefits? Why do I want to use them? What should I craft as admissions? And how do I respond to them? Well, the first thing to understand about admissions is they're limiting tools. They're ways to squeeze down to get facts admitted to so we don't have to prove them at trial, so we don't have to bring additional witnesses in, so we don't have to worry about court time related to those items. One of the examples I gave you in earlier sessions was that you had a document and you sent it to them and said, is this the full and complete copy? To authenticate that, admit or deny. Other ways can be to have them admit or deny specific facts that you think are important. Admit that you were standing on the stairwell on 4th and Main in the Johnson building at the time you heard the gunshot. Then I don't have to go through establishing where they were at that time. There are other kinds of admissions that are very effective when people produce documents to you. As we mentioned, please admit that documents, bait stamp number 1 to 52, are all the documents which comprise each and every allegation you have as to the wrongful billing, the duplicative billing, the unnecessary billing. That's a yes or a no. If it's denied, then we have problems with the production request because that means they weren't honest. If it's admitted, now I've got my box, my bed that they have to sleep in of that total amount of damages, and it may enable me to do certain things like get summary judgment, partial summary judgment. We believe that we're owed $1 million in wages, but we know for a fact that they've already admitted in emails that $86,000 is due to our client. Requests for admissions. Please admit that $86,000 is due in wages and compensation. And even better, if you could take the exact words they use in their email, please admit that $86,000 is due in wages, compensation, and other income through the date of December 25th, because that's what their email said. Now they say admitted, but we're not admitting to $1 million, but admitted. What do we do? You had the response, push the button. Motion for partial summary judgment on the wage claim. Why do I want to do that? Because I want to get summary judgment and say I have a judgment against the defendant, and I want fees. You got an entitlement to attorney's fees. Which brings me to my next point about attorney's fees. When somebody denies an admission and you have to prove it, you get attorney's fees for proving it. That means in a slip and fall case where normally there'd be no attorney's fees, I don't even have to do a proposal for settlement if I don't want. I can do a request for admissions that says, please admit that you were not in aisle 3 at 927. Because we know the video camera shows that. And then they say, denied. And I prove at trial that that was one of the central material facts in proving that they couldn't have physically been where they said they were when they slipped. I win that case, and then I get all my attorney's fees paid for. Wow. Press your friends, scare your mother. This is, admissions are the most underutilized tool. Don't request admissions to be admitted of things that they won't admit. Admit that you maliciously and intentionally and recklessly abused the plaintiff. The only time you use that kind of admission is if you really think that these people are not going to respond timely in which case, if you don't respond, an admission is deemed admitted. So if you're using tactical warfare and you have 30 interrogatories, 30 admission requests, and 30 production requests you want to send out, and you happen to send out 4 admissions requests on Monday, and the next week you send out 3 admissions requests, and the next week you send out 6 admission requests, and then the next day you send out 9 admission requests, then the next day you send out 3 more, and that person is busy with 300 other files, they might blow a deadline. So if you believe you're dealing with people who may not be deadline sensitive, break up your admission requests. It forces them to pay attention to dates. And when you break them up, if you can break them up by topic, it doesn't seem so haphazard. So when you're doing that, you're establishing some dates where if they don't respond, it's deemed admitted. If they do respond and they deny it, and you prove it, it's material, you're going to get fees. So I want to use admissions early in a case, as well as when I get documents and other things. What are the kinds of things I want them to admit? Think about what are the elements of your cause of action and what are the facts that support that. And whatever fact you can get to support it, make them admit it. And think about baby steps. Admit that you were in the Publix on January 5th. Easy to admit. Okay, I admit that. Doesn't sound like they're accusing me of anything. You know, admit that you walked down the aisle, which was described in your deposition as aisle number 2, marked food and beverage. I'm squeezing that down. And I'm getting specific facts that I think are going my way. Now, understand that if you're taking a deposition and you get those questions answered, you don't need to worry about admissions. But if somebody says something in a deposition, I can't get attorney's fees for that. But if I ask them up front, the admissions, and then later on I prove in the deposition that they needed to admit it, I get fees. Dreamy, baby. Dreamy. Okay? So when you can, recognize that the use of admissions for squeezing on the issues or getting summary judgment or proving facts to be true that they deny is very effective. And I will tell you, there is a large group of lawyers that just deny everything. And that is just, what do I do when I get that? Celebrate! If I've asked the right questions, they're incredibly difficult to deny. And again, if somebody denies things like authentication, then the moment they deny it, I push the button. And that button is a notice of deposition of that witness or subpoena ducis tecum directed to the witness that I got to prove that it's authentic, the records custodian, whoever it is. You denied that it was authentic? Okay, records custodian depot. Dear so-and-so, thank you very much for your response. I noticed you denied the allegation relating to that this insurance policy was an authentic and true copy. It was authenticated. It was whatever it is you say. It was admissible. Please, here I've included the following 62 dates that I'm available for the deposition of records custodian. Please respond within 5 days. If you do not, I will unfortunately have to pick one of the 62 dates and set it unilaterally. And when you have to set things unilaterally, you have to write a letter. I will tell you, it's quite compelling when you have 62 dates. The guy can't say, I was unavailable, they're unreasonable, they're unilaterally setting it. Judge, I took every day of the week for the next 3 months and told him to pick one. So you can use it to then create, I don't want my guy depoted. Well, then you need to admit it. Or tell me why you're denying it and have me rephrase it in a way that you think there's some word. The word the isn't defined? Okay, I'll define the. The equals the. Okay? So it's very important that you do that. If you're using any terms of art in your admissions request, make sure you define it. If you're using the back alley, and the back alley is on the corner of 4th and Main, then say, you know, when we refer to back alley, in quotes, back alley should be defined as that area between 4th and Main. Now I don't have to describe these admissions in such detail. I'm just referencing to those terms of art. When I say computers, I mean the 4 laptops that were used in such and such. Please admit that you had 4 computers on you at the time of the death. See what I just did? Definition shape, because I want simple admissions. Why? Those admissions can be read to a jury. They're particularly useful when you have emotional situations and things like that. And when you could say, they've admitted that they suffered this or didn't suffer that or whatever, I can read that to the jury. They call that cocktail talk, you ready? Publishing. Okay? Your Honor, may I publish these admissions to the jury? You may, Mr. Major. The plaintiff has admitted that he's a loser and has no friends. The plaintiff has admitted that he really has no claim for wage, whatever those are. And I get to read them to them, and the judge says you are to assume that those are true. They've been proven to be true, and you are to take them as that evidence. I also can use them for motions, for summary judgments and other types of motions. So admissions can be a powerful tool. Well, how about responses to admissions? How do I respond to admissions? Well, there's a couple of ways to respond. Actually, 3 to be exact. I can admit the admission, I can deny the admission, or I can say I have no ability to admit or deny the admission. Okay? And aside from objections to them, there are no other methodologies for responding to an admission. If I admit the admission, it's deemed admitted for purposes, and it's also sometimes you want to admit things. You don't want to go through having the custodian either. You don't want them to take your custodian depot. You don't want them to do this, so you do that. If you deny, you open yourself up to attorney's fees, but maybe it's a valid denial. If you're unable to admit or deny, you have to explain why you are unable to admit or deny. You cannot just say, I cannot tell, or I don't have the document in front of you. You have to say, we have made the following efforts to attempt to secure the information in order to admit or deny it. We looked in storage, we looked in our computer database, we called my mother, we asked friends, uncles, and we were unable to find the documents or the information which would allow us to admit or deny it. If you put anything less, it is an admission. Most people will put unable to admit or deny and nothing else. That is a request, motion or request to deem admissions admitted. Or you don't have to file the motion. You just consider it admitted. You file a motion for summary judgment and you cite that as admitted. Judge, they can't just say unavailable, unknown, can't deny it this time, whatever, can't admit it this time. That's just not legitimate. Here's the rule, directly on point, and the rule says you have to show all the efforts. This unable to deny stuff, you got to have a high burden. Why? Because they don't want everybody doing that. Objections, very much like production and interrogatories, have to be specific. But as you imagine, since we have statements that are being made, we're going to have a much narrower category of admissions. And we might have an attorney-client admission. We might have an admission that is overbroad in its language or it's vague, but we need to explain why that's so. But you're not going to have as many objections to them as you normally would, because it's harder to make an irrelevant or won't lead to relevant evidence on a statement of fact that sounds like it's related to the case. Sometimes you might want to do an admissions request directed to their complaint. Because if I'm the plaintiff, I don't have to do an admission request directed to their defenses because they answered. So they admitted or denied. But if I'm the defendant, I might, if it's not a verified complaint, fudgy, wudgy. I sort of meant that. I don't know anything. My lawyer knows everything. You could take allegations of the complaint and you could say, please admit that that's true, or please admit that that's false. Please admit that the allegation number 23 wherein you claim we committed fraud is false. So you can use those admissions in a very powerful way, and it's tough to object to that. It's your allegation, right? If you find things that come from depositions, that come from discovery, you can use those in your admission request. And if you're using this Excel or whatever spreadsheet or trial preparatory materials, you can then, as the person admits, now that's a fact that's admitted. I don't need that records custodian, or I don't need to go about that fact anymore, and I don't need to worry when the lawyer says, I need the witness's deposition. We got to find in that 900-page deposition where she said the. Hurry! What's wrong with you? Okay? When you could say, in my 5th request for admissions, admission number 73, because I sequentially numbered them, I already asked, and he admitted the was the. So, sleep well, my friend. And you will find that the level of likeness directed towards you will geometrically or exponentially increase. So, what you're doing, again, same methodology, is I am taking a shrimp net and I'm throwing it out and saying, tell me everything that's related to the case. And then I'm pulling it in and saying, okay, I want the lobster, so I'll pull the lobster out, the material things. Then let me test to see, these are nice shrimp. Let me ask you some more questions about these. And I'm squeezing and squeezing and squeezing, and I get them down into a box where I don't care what a witness says, so long as he says it. Now I have this, they're locked into this. Then, when you take further depositions, or when you go to trial, or you go to summary judgment, or you go to some hearing that's evidentiary in nature, you can take these admissions, take these documents, and take these things that are out there. Now, sometimes you can avoid wasting admissions, because you're limited in number, by, when you get documents in production, write back to them. Dear so-and-so, I've received the following documents: the insurance policy, the letter from the president, the bank statement, and the so-and-so. Please confirm with me, or please let me know in the next 3 days whether you would agree that these could be considered as authenticated documents so we don't have to call the records custodian. Depositions. If they say yes, then I don't have to do admissions. I can save those admissions. If they say no, push the button. Because we're going to depose those people right afterward. And if you do things chronologically, right after you get something, it's extremely powerful. Because then you say, Judge, the only reason why I took the depo, the only reason why I did this was, this is what they gave me. I asked them to. I don't wait 9 months and then try to remember what I forget, what I forgot that I remembered I forgot. Okay? So if you do it proximally, you understand that each item ties to another item. It's a flow. If you read some response, and your feeling is, I don't have to do anything, you need to change that feeling. Okay? You need to say, unless it is so antiseptic, unless it is just so simple, it probably is triggering a depo, an admission, a production request, an interrogatory, a letter, a motion. And if you pay attention to that, then everything flows off of everything. It also puts enormous pressure on the other parties. In that case example I'm using of the unreasonable, duplicative, and unnecessary, I'm asking the lawyer, I don't care what your position is, but you have 2 choices. Have a position, lose. Here, 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 here. So I don't care, but once I get his position and I realize that he's not complaining about all the bills, even though his complaint says all the bills, I can start squeezing down and finding out, okay, it's 15 bills. Okay, it's 300 entries, not 30,000. Okay, it's 40 documents that he needs, not 300. So what have I done? I have then taken the admissions and used them in a weaponized way that both reduce my time down and provide for me possible attorney's fee things. So if I do that, I'm really creating something that is spectacular. Does everyone follow the admissions, production, and other things? Since we have a little time left, let me just talk to you a little bit about some communication stuff. And if I could ask Patty to hand out this, it would be great. Let me tell you a tip about writing emails that from now on in, everyone in this room needs to do. Absolutely need to do. Every time you write an email, and you'll see the example that I give, you put your letterhead on top of the email. So whenever you write an email, set up a letterhead and use it every time. You can either do that in the stationery section of Outlook type things, or you can write an email to yourself with just the letterhead, and then you copy it in each time. There's another way that I can tell you it's more technical. But the concept is that what you want to do is every single thing you write in an email is not an email. It's correspondence. When you're reviewing a bill and somebody's trying to pay attorney's fees, when a client is reviewing a bill, an email sounds like 3 words. Correspondence sounds like you're writing more. So everything is billed as correspondence, not billed as emails, whenever possible. But more importantly, if you look on there, the letterhead, it makes it look formal. So let's say I sent the dates out, and the person said, I'll take May 5th. I don't write back, yep. I don't write back, okay. I write back, Dear Mary, I want to thank you so much for giving me December 5th as the date for the deposition of John Smith at XYZ location on X time. Consistent with our prior agreements, I will prepare the notice of deposition and the ducis tecum, and I will forward that to you. Love and kisses, me. Okay? Once you do that enough times, you'll be able to copy and paste that type of format. But every time, you always write what the person is actually doing, and you put it in a letter form so that it is now clear what they have given you or not given you. Always in letterhead form. Every single correspondence I ever write on emails is always got the letterhead. If your lawyer has titles, you can put the titles at the bottom, whatever it is. But the concept is, if you have titles, you should put your title. If you don't have a title, if you are called paralegal, then go to your lawyers in your law firm and say, I would like to have a new title, if you don't mind. I would like to be called the Director of Paralegals, the National Paralegal of Paralegals, the Lead Paralegal, the Senior Paralegal, the Executive Senior Paralegal, the Head of Litigation Paralegal. Something which connotes titles because, number one, when I, on the lawyer, get on this side and I realize you're the Senior Paralegal, I'm going to read my discovery a little more closely because you're the Senior Paralegal and not just some paralegal who may have gotten out of school last week that I don't care about. Also, looks great on a card. And when you have those cards can be used when you hand out, and it connotes, it makes you feel good, and you are the lead paralegal. You are. So why not brag about it? Yes, ma'am.
Can you just clarify the benefit of putting the letterhead on the top of the email versus the email with the signature blocking?
Sure. When you put letterhead on email, and it's more stylistic than everything, it creates more of an elegant and more formalized feel to your correspondence. It also makes it much more justifiable because if you ask judges and they look at correspondence and letters, or if you ask people who are paying bills, they tend to look at items that have letterheads as more formalized than yep with your signature thing, or yes, I'll do it. Because when I put yes, it seems like it's more difficult to bill that at a 6-minute increment than if I explained what it was. And if you're trying to be reasonable and you're trying to show your value, you should do that. It also really works well when you print them out and people are reviewing them because it's a nice correspondence file that's really clear and it looks like you've professionally written every letter. That's huge. If you don't believe it, try it and watch what happens. Everybody. And I'll bet you may not be able to name a person who does it, but now all you are going to do it.